Perfect. We are live. So, good evening to everyone. We have with us Advocate Saransh Chaturvedi, Associate Khurana and Khurana Advocates and IP Attorney. He has done his LLM from Indian Institute of Technology, Kharagpur, having a specialization in intellectual property strategy in the corporate, preferably in trademark and copyright domain, and have worked on IP advisory. Currently working one of the leading IP law firms in India, Khurana and Khurana Advocates and IP Attorneys. I welcome you, Saran sir, on LedX, and we
Thank you
are
so much.
for a great session.
Thank you.
With this, I present your PPT, and we can start the session.
All right. So, should I start?
Yes, sir.
Yeah. So, thank you so much for your kind introduction, and I'm also glad to have that you have invited me here for a wonderful session on workshop on legal drafting. So, basically, starting with the first of all this concept, uh, starting with this webinar. Legal drafting, if I may say so, is something which even if a lawyer who is having 20 years of experience, if you will ask him, does he know legal drafting or is he an expert in legal drafting? Definitely, if he's a good lawyer, I will say that he will never say that he is an expert of legal drafting. Legal drafting is a perspective, or rather, it's an art which probably a lawyer learns in his whole lifetime. And understanding this legal drafting does not take one day, one week, or rather, it's not a matter of even 1 year, 2 years. I, being having an experience of like around 2 to 4 years, I might not say that I am having an expert over legal drafting. So, as I told you, even a lawyer who is having an experience of like 10 to 20 years might not be able to say that he's an expert, because legal drafting, as I told you, is an art which requires particular interpretation at different stages and at different level and at different time. You might have a writ petition, you might have an SLP, you might have a different interlocutory application, you might have to draft an RTI application, you might have to draft an IP advisory application or an IP prosecution part. Whatever thing you may draft, it all requires a different level of drafting. It all requires a different type of drafting, and it all requires a different thinking. So that is why I told you that a legal drafting is something which we as a lawyer learns in his whole lifetime. So my next slide, please. Yeah. So in this discussion, rather in this small discussion, I will try to make you all understand as to what actually is legal drafting and what are the nuances of legal drafting. You might be you might have heard about what is legal drafting, and you might have also heard about in thousands of courses on Google and at various platforms, where people used to make you learn about legal drafting and make you learn about what all you need to do as a part of legal drafting. But the thing is that still there are a lot of intricacies, there are a lot of doubts, there are a lot of ambiguities which pertains to actually what to do in a legal drafting. So I hope and I believe and I assume that we all know as to what legal drafting is. We all know a simple understanding of what legal drafting is. And even if you don't know, I will be here to tell you all about legal drafting. But a generic view, since this PPT is only for a small, tricky information basis, please don't rely on that. I have not made this PPT on a very informational basis. So if you can rely on my story, it will be very much better. So this whole issue of perspective of legal drafting, right? In thousands of places on Google, on different websites, you might find this legal drafting being a documentation of law, or rather, you know that what legal drafting is simply a drafting of a legal documentation. So actually, still, if it is so simple, where the problem is? Next slide, please. As I told you, thousands of places, you know what is legal drafting: documentation of law and fact, and a drafting of a legal documentation. So you all know it, right? But I have written it, you know it all. Let's step on second discussion. Why? This answer you will be getting in my end of my presentation. That why I am saying that you know it all, and let's step on to the second discussion. So let's step on to the nuances of the legal drafting in my next slide, and then we will move on to what is legal drafting at the end, and then you will understand as to why I am saying so that you know it all, right? So coming on to the perspective of nuances of legal drafting, when we try to deal with this legal drafting, it is very true that we need to understand what is your facts and what is the law that is applicable. Now, the main important point is that when facts is there in front of you, it is an important art or it is an important trick as to how you present your fact in front of the court or wherever you are appearing or whatever you are doing in terms of documentation. Where are you appearing, where are you filing it, doesn't matter. The main principle matters is how effectively you are documenting, how effectively you are drafting or legal. Even if it is a small contract between two people where no such courts issues are there, still the drafting capabilities needs to be there as such that you should rely on the facts and you should rely on the law, and you should bring out that drafting capabilities which the people or your reader or your client must say that yes, it's a good drafting. As I told you, there are thousands of courses on legal drafting, but I have not taken up any of the courses and I have not taken up any of the these are online classes of legal drafting. I don't know, but actually the first and the most important point that I feel that it is missing over the over all over the internet and wherever it is being written about legal drafting is the main question as to what you want. See, whenever you are fighting for something, you are fighting for something which you want. You are fighting for something which actually you feel that it is your right and you should be getting it out, right? So the problem with the legal drafting is at various point of time and at various stages, the people who is drafting the legal that particular documentation doesn't know or is pretty much confused, or rather I can say that it's all about the environment that is going getting around himself or herself, is that they are not very clear with what actually they want. I will be giving you an example and I will be making you understand with that particular aspect that how and when it is important to have that aspect about what you want is something which is very important. Let's say for example hypothetically, uh, let's say for example I'm just giving you a hypothetical example to understand as to what I am trying to implicate with this particular sentence, what you want. You are fighting for a case and that case pertains to let's say for example women empowerment or a woman's right. So when you are trying to get into the perspective of women empowerment or women's right or intricacies into the cases, again the question will come as to what you want. The question and the answer to that particular wanting is only dependent upon you and the facts of the cases. So let's say I told you about women empowerment is there and women this particular issues of women rights. You are fighting for this women rights. So when you are trying to deal with this woman, right? First of all, what you will you will you be wanting is a relief to that woman. That is very something which is very much often true, and it is being relied by everyone. You will be asking for something which you can get relief of from the court. So you will be wanting for a particular relief of that for that woman. Secondly, you will be asking for a challenge of law. Let's say, for example, you are questioning a law that is illegal and you are finding for fighting for a case that that particular provision of law is illegal and particular provision of law should be either changed, amended, or whatever you are asking for, right? So let's say, for example, you are willing to challenge a law. You are challenging a law that this law is illegal and this law should be amended. So okay, fine. If yes, you are challenging the law, then on what basis you are challenging? If no, then move ahead. Afterwards you come to the provision of law. Let's say for example your particular provision or rather your particular aspect where you are wanting the relief of that woman is not even there in the law itself. So you will be asking to have a new law which ultimately court will not do it. Why I am telling you all these things is because to make you understand that before drafting, before trying to deal with such a drafting process, you need to understand as to what actually you want in that drafting. You are wanting for a relief of that person. You are either challenging a law. If you are challenging a law, yes, what is the basis of your challenge? If you're not challenging a law, okay, fine, let's move ahead, right? So when you are trying to deal with this particular I think my ppt is not there. So when you're trying to deal with this particular what you want, then it is important to understand that the relief, the challenge, the provision of law must be very much in consonance with actually what you want or what you are praying for before the court, right? So when you are, like for example, I used to take classes of research paper writing. So when I used to take the classes of research paper writing, I used to tell my students that whenever you are trying to take a research paper, whenever you are trying to write a research paper, some things are very important. Like, there has to be a particular research question. Without any research question, you are not able to write a good research paper. So when you are into a research question or into a research paper, then you should be very much clear as to what question you are addressing it upon. Similarly, I'm not saying that research paper and legal drafting is more or less very similar. It has a different values, it has a different structure, but some points, some viewpoints of research paper writing and legal drafting are in consonance with each other. And that is what I am saying, that what you want, what relief you want, is something which you need to be clear of. I'm not saying, I'm not pinpointing you everything that what you need to do. I'm just telling you you should approach before, while getting into the drafting of before getting into such a legal drafting. Because I'm telling you all these principal approaches because of the fact that probably I might not be there tomorrow, I might not be there with you tomorrow, so you must be understanding the principal approach. I'm not saying that there is a universal rule of legal drafting. There are no universal rule of legal drafting. Some Every lawyer in this country, or not even in this country, in the world, has different area, has a different process of their own drafting purpose, right? So there, if there are 1,000 lawyers, there might be 1,000 uh, uh, process of drafting. So there cannot be a universal rule of drafting. Why whatever I am saying is only because I am trying to make you understand the process and the principal approach behind legal drafting. So coming back, you are very much clear as to what you want on this fact. Okay, fine, I want a relief, I want to challenge the particular law, and I want to challenge this particular provision of law, right? After such a challenging, and after such a provision, and after getting into all sort of thinking that okay, fine, these are the things which I want, now you are coming on to the second portion, and the major point is the fundamental question of law. Like for example, I will give you an example. Let's say, for example, as I told you hypothetically, that you are dealing with some women's right, and and you are also specifically dealing in Muslim law. So your fundamental question is some or the other related towards the minority rights. Let's say hypothetically, I'm just trying to make you understand. So let's say you are dealing in minority rights, you are dealing with some women empowerment, women's right issues, and now your fundamental question of law is totally based upon Article 14 and Article 19. I'm not saying Article 14 and Article 19 will not be applicable in your case, but but when you are trying to deal with such a particular issue where women's right, as and more particular, the minority right is under consideration, you must be very clear as to what fundamental question of law you are trying to deviate into, and what fundamental question of law you are trying to put in front of the honorable court. So the point number one, you are very much clear as to what you want. Point number two, you are very much clear as to okay, fine, these are the questions of law, and these are something which I feel that these are the fundamental question of law, which I feel that there should be the honorable court should actually deviate and actually should delve into all sort of things where my relief and my fundamental question of law is in consonance with. As I told you, there I have read thousands of petitions where the issue of the fundamental question of law and actually what you are wanting is totally different. This makes your case very weak. So when you are not able to have a good consonance between your relief, your what you are actually praying for, or what you are actually wanting in your document, and what is the fundamental question of law, then half of the fight you have lost already. So you need to have a very much good understanding that both the thing, the fundamental question of law which you're addressing, and the legal provision which is, like let's say for example, which is debating towards the woman's right, must be in consonance. And now you are coming on to the third basis. Next slide please. Third basis is the case laws. So when you are trying to deal with the case laws, it is very important to understand that, again, reiterating what I have said, that your case and your laws and your arguments must be in consonance with your relief and the question of law that you have already put before the court. So, what is an important factor here? Let's say, for example, you are dealing, like as I gave you an example about women empowerment, and as I gave you an example that you are dealing with the minority rights. Your relief deals with the relief of women, and you are challenging a provision of any law. You are not able to bring a good fundamental question of law which the court might rely upon, and also the case laws which you are relying upon is not overlinked with the relief and the question of law. 100% the court will not be interested in listening to your issues and your whole argument, because you are not able to link your case laws, your arguments with what you actually want with the fundamental question of law. So if though these three particular aspects of the drafting procedure, you are not able to make it in a compatible and making it in a one line, then ultimately what will happen is that you have lost 70% of your fight, because you are not able to rely on your arguments, your relief, your functioning, you what you are actually asking before the court is something else, and what actually you are questioning, what actually you are putting the fundamental question of law is something else. So all these three are getting into different directions. So your legal drafting procedure becomes very, very, very weak. So coming back to these three portions, it is very important for a legal drafting, like the first point, what actually you want. You are very clear that, okay, fine, you are wanting that there should be a relief, you are challenging particular provision. Coming to the second point, you are challenging a fundamental question of law that is totally relevant to your relief and whatever you are wanting, that is a challenging the provision or the relief that you are wanting, right? And your case law, whichever caseless law you are giving, whichever argument you are giving, is particularly linked towards the relief and the question of law, then it makes a brilliant drafted legal document, because everything, either being the case law, either being the relief or whatever you are wanting for, and either being the question of law, is on the same line, right? So when all these three are on the same lines, you have won 70% of a fight. Last but not the least, the facts. When you're trying to deal with this the legal drafting, you must have heard that those lawyers, the experienced lawyers who have command over the fact, who have command over the issues and all sort of things, are able to win the case by only telling the molding the facts with the law that is applicable to the facts. Having a very good command over the fact is very important. So it is very important to understand that the facts must relied upon the question of law and the relief and the case law. Again, I will repeat as to what I have told you. So when you are drafting the particular legal document, make sure that your relief, or rather what you are actually wanting in your legal document, is very, very, very clear, concise, clear. What fundamental question of law that you are putting forward is very clear and must be in consonance with your relief, actually what you are wanting. For example, I gave you that you are wanting something else for a minority right, and you are questioning some else question of law, right? You are challenging something else. So uh, there is no consonance between your particular question of law and your relief, right? And the arguments and the case laws which you are dealing with must also be in consonance with your relief and the fundamental question of law, in totality the facts of the case. So facts, relief, question of law, and case law. My next slide, please. Four pillars. So like for example, four elements of contract you must have. You all know, right? Competent party, mutual consideration, then it's come to legal purpose and mutual agreement. There must be an offer and acceptance. We have all studied this all four elements of contract. So in that manner, the four contract and the four pillars of contract is very much specified in the act, but there are nothing specifically given in the legal drafting procedure. So as per my experience is concerned, as per my legal drafting is concerned, as I used to do some sort of drafting, I feel that these are the four pillars of drafting which every person needs to be having a command over. The facts must be very, very, very clear. The question of law must be very clear. The case laws, arguments which you are trying to put must be in consonance with the question of law, and the relief, what exactly you want, some must be in consonance with the case law and with the question of law. In any case, if all these four are in consonance, are in compatible mode, are in one line, you have won half the fight. In any case, any one of the factor is missing, any one of the factor is not in the line, any one of the factor is not supposedly in the framework of the drafting procedure, then you are going to lose the drafting and lose the case itself. So to have a good command over the law and to have a good command over the facts is required in legal drafting. But more important, actually what is legal drafting is about the communication skills. So whenever you must have heard about legal drafting, it's all about communicating. So you have heard it's all about communicating. But what to communicate and how to communicate is an important factor, which I have is mentioned in my PPT. So when you are having a particular facts with a particular question of law and the case law, the arguments and the relief, what you exactly you are wanting it, these all four things, these all four pillars of drafting, when in consonance, provides you a perfect level of communication, because you are there in front of either in a court of law or in a tribunal or in any body. You are trying to communicate your particular facts and particular circumstances and law in front of the judicial authority. When all these four pillars are not in consonance, you're not able to communicate it. So for a perfect communication of of your case, all these four things needs to be very much aligned with, and eventually you need to understand as to what actually you are able to communicate and how you are communicating it, right? So probably I'm not actually, I'm not getting into all those sort of things of legal drafting where I am saying that the drafting should be very much clear, the drafting should be very much concise. And because we all lawyers have a pretty much good habit of getting into more complexities, uh, in spite of getting into more simple language, they used to get into more complexities, which ultimately leads that the readers are not able to understand what actually you are wanting about. So these all complexities often results into a bad drafting, which I may say so. I will not say a purely bad drafting, because somewhere or the other such drafting is also required, thanks to the already prevailing legal industry. But I feel that their legal drafting and the legal issues must be very much clear, simple, and concise, which you all know. Why I am saying all these particular pillars and all is what I am trying to make you understand. The principle based approach is actually whenever you are trying to deal with the drafting process, and when nobody is with you, and you are just doing everything in your at your own, then it is very important to understand that you have some principle based methods in your mind which makes your job very, very simple. So if everything is in your mind, let's say for example, if everything is in your mind, fine, facts are clear, done, question of law done, case laws, arguments done, and what you want, you are very much clear, then ultimately your job becomes very easy because you are able to communicate. Let's say for example, in your college, when you are presenting your paper in the viva and research paper presentations, whenever you are very much confident as to what actually you have written in your research paper, you don't need to prepare much, isn't it so? Because you are very much clear as to what you have written, and you are very much clear as to what you want to communicate. So communication is a very important skill, and communication is something which is important here. But the real question is what and how to communicate. So these four pillars of drafting, which I am trying to tell you out, gives you a simple glimpse that what you need to communicate is your facts, your question of law, your arguments, and your relief, exactly what you are wanting in one consonance. Nothing should be out of line. There has to be a one simple straight line which tries to make the other party or the judicial authority very much clear as to what you are communicating and how you are communicating this. This is what I wanted to try to make you understand, the principle based approach of legal drafting, because everywhere you will try to understand, try to learn about legal drafting, thousands of courses about legal drafting, that okay fine, legal drafting should be there, you should also use this languages, you should be clear, you should be concise, you should communicate, you should be documenting. These all things are very much vague and ambiguous in terms of whatever they're trying to tell you, but nobody is trying to telling you what the experienced analysis as to how you should continue with the legal drafting. Moreover, the legal drafting is not a 1 day or 1 hour period. It requires a huge amount of time. As I told you in the starting of my lecture, that in a legal drafting, you even a 20 years experienced lawyer might not say that he's an expert of legal drafting, and even 2 years, forget about 2 to 4 years of people who have done. So there is no such sort of rules and applicable facts and universal procedures to be followed on a principle that has to be followed on a drafting purpose. But these four pillars, I'm not saying these four pillars are sine qua non, it is an indispensable part. No, I'm not saying that. Please don't rely on these four pillars itself. I'm just trying to make you clear and giving you a glimpse of actually what all are such drafting procedure is, because drafting contains a lot and lot of lot and lot of factors, lot and lot of procedures, which I'm not saying, I'm not here and I'm not nobody to tell you that these are the four pillars and done finish, like four pillars of contract are these four pillars of contract which is coming from the last 100 years. But I'm not saying that these are the four pillars of drafting, these are the only four pillars of drafting. But I'm just trying to tell you that these, if you are trying to be in consonance with all these four factors and elements, you will be having a very good drafting, or the result of drafting will be very good, and you will be able to communicate at a very good pace and as at a very nicer manner. uh, Next, I will be also dealing with a hypothetical situation where I will be putting forward you a particular case, and you will and I will expect that you will be doing some research onto this. Please, next slide, please. Yeah. So I don't want any answer to this, and I don't want that you should also give some. You should message the answers and all. But let us try to understand the legal drafting procedure in in such a concise and a clear manner through this example. So I gave you one hypothetical example, and the example is like that Mr. A is an owner of Mr. Of a company X. A has a large land area on its name where another company Y, whose owner is Mr. B, does some activities on that land. A knows and has consented to the same. A knows that the activity might be harmful for the nearby residents. Hence, A wants to enter into a negotiation with B where A wants that B should have a total risk of injury from his work and A should be protected. So this is a simple fact where the facts are more or less very clear, because it is very much it's more than simple, right? You will be able to understand what is the facts. So A is the company X is, he's the owner of a company X, and he is having a large land area where Mr. B is doing some activities, and A knows that the activity of B is hazardous in nature, and it might harm the nearby residents. So A wants to enter into a negotiation with B that whatever risk the work is there, he will be Mr. B will be totally liable for this, for the whole activity, and not A. As I told you, I don't want any answer to this. I just want that how you should approach while dealing with such cases. And suppose, let's say, for example, you are being the lawyer, how you will be approaching this case and how your thought process will be, right? So what you will be doing it, you should be asking some questions to you in terms of your research. Don't just go to the research, don't just open the bare act, and don't just try to find the relevant provision. Just first of all think and ask yourself that why actually you are relying on that provision of law. Let's say, for example, here the issues are in terms of property as well. Here the issue might be in terms of contract as well. Here some sort of torts matter will also be there, right? So totally a good case might be very much visible, that a contract issue is there in terms of a property disputes, and also in terms of let's say for example the hazardous nature and the statutory requirements and the liability, the third party liability is there, right? So asking question to yourself is an important perspective. So you, let's say for example you are asking question to you that how you are conveying a real property from the owner to a third party, what provision you will use. These are the questions which you yourself is asking to yourself. Ki, fine, okay, these are the facts, I am very much clear to the facts. Now pondering upon the issues and pondering upon the legal drafting, what I will think. First of all, so first of all I will think that okay fine, how I'm conveying the real property from the owner to the third party, what is the basis of my doing it. Fine, let's say for example you solved your first question and you are now moving on to the second question. Now you are, second question you are asking, okay fine, done, the I have dealt with the provision of law where I am conveying the real property owner and I am conveying the property from its owner to the third party. The second question is how you are establishing the relationship. Even if you are trying to tell that okay fine, the relationship between Mr. A and Mr. B is only of tenant, then how you are establishing the fact that there has to be an hazardous activity and there needs to be some negotiation where A will be protected totally. How you are establishing the relationship between the such a tenant issues, you need to think about that. Now okay fine, let's say for example you have thought about it, you are now clear with the provision. Again I'm saying I'm not asking any answer from your side, I'm just trying to tell you as to how you will be dealing with such cases, because these are something which is, which you need to understand. Giving a particular understanding is one thing and giving a particular answer is one thing. So I can just give you an answer, okay fine, you will be dealing with such cases and then done over. But I'm just trying to tell you how you will be pondering over the legal drafting issues when it will arrive in future, right? Hoping that everybody is in their college days. So let's say for example you are trying to deal with this such a factor that okay fine, how you are establishing the tenant issues. Next, if let's say for example if there are any work and employment issues between A and B, how you are establishing that. The second question might be, the third question might be that, and the fourth question might be that okay fine, on what basis you are giving the liability to B and totally indemnifying this person A and protecting the Mr. A or over all the liabilities. So the point is, some of the questions and some of the things which you need to understand on yourself, which you need to understand, okay fine, this is something which you need to research upon without exactly going on the bare acts and exactly just googling it. You need to ask yourself some questions before going on to the research area. Okay fine, let's say for example you have dealt with some of the questions. Again some questions might be there. Okay, why are you relying on the provisions? As I told you, let's say for example you have done tenant issues, you have done that, how are you giving the liability to Mr. B or totally protecting Mr. A. So let's say hypothetically you got a provision where you are saying that okay fine, Mr. B might be totally liable but Mr. A will be protected. Why are you relying on the provision? What is the basis of your relying? Is there any particular case laws behind that? These are some of the questions which you will again ask yourself before getting into drafting. Why I'm saying all these, because these questions, if you will get the answer of all these questions, it is very true that your drafting process will be more than sufficient and more than the best. Because the fact is that you are trying to communicate it to yourself as to what you are wanting. The first point which I try to reiterate in the starting of my webinar, that you are making yourself clear as to what you are wanting it. And now you are delving into the fundamental question of law, that okay fine, these are the things which I want, and now I will be dealing with such as particular questions of law, and now I will be dealing with such a question of law relying on the arguments which I will be making as per the thing that I will be wanting and as per the question of law is concerned. So okay, why are you relying on the same? Actually, does that provision solve your purpose? Is the one important point. You must have read, okay fine, article 14 read with article 19, article 21. So you need to understand, okay fine, if let's say section 279 solves your problem, so whether 279 alone is solving your problem or whether 279 is solving a problem along with some other sections. So relying on the provisions, relying on the solving of that particular problem, all these questions you need to ask about yourself. Does that actually relates to a fundamental question of law? This is also one question. And also there might be I can make thousands of questions on this, on this, right? So the whole sole aim is to make you understand how you should go ahead with the drafting, how you should go ahead with your drafting purpose when things are not clear to you. Because when the facts is in front of you, you need to understand you have a good command over the fact. That is true. But you need to understand as to how you are moving forward, and as to how you are doing it in a sense that fine, these are all things which is totally done. These are all the things I am totally aware of the facts. Done. Khatam. Now concentrate on the questions which you are asking to yourself. Believe me and trust me that if you start asking questions to yourself, if you're trying to solve most of the queries asking questions to yourself and researching onto this, half the problem is solved. The major mistake which people used to do is that whenever you are having such a point, like let's say for example when you are having a particular issues, like let's say a facts or a any case, even if it is a bail matter, even if it is some else matter, then you will be surprised that most of the people doesn't question themselves but start retaliating and start googling it. Okay, fine, how I will solve the issue. So the issue, the point is you need to ask some of the questions to yourself to make yourself very much clear and actually very much perfect, concise, that okay fine, I am wanting this, my fundamental question of law is this. Now my argument will be totally inclined towards the fundamental question of law as per the relief is concerned, and I am very much clear with the facts. These four things are clear and it's done. So now you will be moving on to the research perspective, that fine, I am clear with the law, I am clear with the provision, I am clear as to how I will establish the tenant provision, I am clear with as to how I will be establishing the workman or work employment issues. I am clear with how I will be relying on this particular provision of law. I am clear that this provision of law totally solves my issues. Then it's done, half of the issue is done, and now you are moving on to onto your research, making a good framework and argument. Giving 50 100 case laws, like for example in our college days, when we used to write an answer, we used to assume that okay fine, the question and is of 15 marks, then it requires at least 10 to 15 pages of writing, right? These all, I can say that these all habits have doesn't work in the legal industry. You don't need to provide 50 cases, because the court will never able read those 50 cases. They will be only relying on the particular substantial portion and substantial case laws. We have all sort of habit of giving 100 of case laws, irrespective of the fact that even if that case law is not in any such in any such in any such importance to the particular case or facts. But we will be giving it because I don't know whether it is a professional need or it is a financial need, but it is not anyhow necessary to give hundreds of case laws. Relevant portions, relevant case laws and relevant arguments is very much necessary for a perfect drafting is concerned. My next slide please. Now the first point, I told you what is legal drafting, and I told you that you know it all. And let's move on to the second point. If you have not seen that first PPT, I will request to just show that first PPT, the first one. Yes, this one. So yeah, this one only. What is legal drafting? You know it all. Let's step on this onto the second discussion. On the second discussion. So last, please move ahead on that PPT. So why I told you that you know it all is because the legal drafting doesn't have any statutory definition. More importantly, when you will do a very poor drafting, there is also no penalty on you. Court might, in some sense, might there might be a chances where court might lash you up and can call and can invite some cost. I might not say, I might not deny the fact as well, but there are no such legal penalty over your poor drafting. So you learn and you learn and you do drafting, you practice drafting, and you become an expert. There is no such statutory definition and universal definition of drafting, legal drafting. You might say there is documentation of legal documents, there are drafting of legal documentations. I might say something else. So that is why I told you there is no such legal drafting. What is legal drafting definition? No drafting structure. I told you, there might be thousands of lawyers and there might be thousands of process of legal drafting. So there are as many lawyers are there, as many legal drafting procedures can be there. Any other lawyer might tell you different process. I told you, I am telling you four pillars of drafting: that facts, case laws, the question of law, and the relief. There might be some other lawyers who might say something else, right? This is what I have gained through my small experience. Somebody will say as per their experience is concerned, right? So there are no such drafting structure and no such formalized way of drafting. But why I am retaliating into these four pillars is that when you are trying to deal with such drafting process, it is indispensable that you need to be very clear onto the facts. You need to be very clear onto the question of law that you are addressing. You need to be very clear on the case laws and arguments which you are trying to put before the court, and you need to be very clear on the relief and actually what you want. Thousands of petitions I have heard where the facts is something different, the person is relying on question of law which is totally different. The case law and arguments, I don't know how, which direction they're relying on to the facts, and in which direction they're relying on to the question of law. And relief and actually actually the client is asking is totally different. You are, let's say, for I gave you the current example about the woman empowerment in my first half. A person is trying to deal with some women's right, and you are questioning something. Question of law is something else, like let's say for example article 14. Article 14 might be there, but you're not trying to deviate into the minority rights. As I whosoever might be listening to my the first part of my webinar, I told you about that. Hypothetically, let's assume that you are trying to fight for a woman's right, and also and also minority rights. So you are okay, fine, it's altogether fine that you are addressing some article 14 and article 19, which obviously will be there. But the concise question of law is not there, right? So at the first point, the facts and the question of law totally deviates into two parts. And then coming to the arguments, you are trying to give 50 case laws, and out of which 5 case laws are there which is more or less relevant. And while you are communicating it to the court is not giving you time to tell you that which case laws are relevant, and which case law, the relevant case laws, you are trying to retaliate the relevant case laws, and court is not giving you time. So all these intricacies results into a very very bad drafting, and that is why there are thousands of courses being going on about legal drafting. And because these legal drafting is very important, but the legal drafting is not taught in our law schools, and it is, I think, a harsh reality which you all people will be facing when you will be coming to the legal industry, because then you will be understanding that okay, fine, the legal drafting is such an important point that one will understand that legal drafting when he is actually doing that drafting. Nobody can tell you the legal drafting process, or rather most of the people today ask me to give a sample drafting or as a petition, so that they can understand. I feel that this is a very wrong practice of getting into a sample things, because again, one more, as I told you, there might be thousands of lawyers and there might be thousands of process of drafting. So you can rely over a particular petition, and you can ask on through mail or to from anybody from a known person, that okay, fine, please give me the petition and I will be relying on to that. But it will not be good on the in the long run. That is why I am trying to reiterate the perspective of what you should be doing on a on that basis, on a principal approach basis. But eventually I feel that people are more or so relying on over the previous draft, which they can get anyhow through advocates, through online materials, and they could rely on those petitions instead of drafting it on your own. These are all activities which I feel, and I suggest to all those people who are under me doing internships and all, to not to do this. Even a small, like let's say for example, I am dealing with intellectual property. So in intellectual property, I used to deal with the trademark issues, patent issues, copyright issues. So in copyright you have discrepancy letters, in trademark you have objections and oppositions. So when you will go to the trademark registry, I don't know how many of people have done trademark as their coursework, but when you will go to the trademark registry, you can just type any application number and you can find the trademark objection reports and the reply to the reports. You will be surprised that I can just challenge you upon this, that you just try to take 100 of trademark applications and you try to compare the trademark objection replies of that hundred of people, whatever, even if it is the client, or a client has been a client through an advocate, you will be surprised that all the hundred of trademark objection responses are totally different, and totally the total language is different, the total relying on the case laws is different, and totally the structure is different. Again reiterate in the same point, that drafting, the legal drafting, there is no universal structure. It is very important not to go beyond not to go behind some already established petitions or sample petitions and try to make your work easier, but instead of relying on some principal approach. Now you are, if you are listening in my this webinar, now you are very clear, right? So you will be going to the facts, you will be going to the case fundamental questions of law, you will be going to the this case laws arguments and the relief. Now I can very well encourage you, and I have a confidence that if you are listening it and if you are noting it down, I don't know whether they will be providing you this PPT or not, but if you are noting it down, you will be very much clear as to how is the principle based approach you will be following while you will be drafting in the future. So this is something which is very important. As I give you, you go to the patents you go to the IP India online websites, and you find this first examination reports of patents. I can again challenge you. You just find hundreds of patent application that is all available on the end. You don't need to have any such solid email ID, login ID, nothing. You just go to IP India. You can just visit patents. You can just visit trademark. Just you need to find the trademark application number, which you can easily find it out in the trademark journals, which is already available on the website. I'm just trying to tell you so that you can just go and delve into how this the crux of legal drafting is there, right? So when you will be going to the IP India website, you will be going to the journals. You will be understanding that all the draftings, as I told you, all the draftings are totally different. Even if somebody has given 10 page of responses and somebody has given only 1 page of responses, you will also be surprised to see that the 10 pages responses might get rejected and the 2 pages responses might get accepted. So these all there is no such hard and fast rule that there needs to be a lengthier process, there needs to be a lengthier perspective of drafting, there needs to be a strong drafting. No, nothing else. It is all a matter of how you are particular about your facts, about your case laws, about your arguments, question of law, and the relief that you want. That is done, finish. I have seen a lot of lawyers who are brilliant in their drafting but have done nothing in terms of their coursework studies. And I have seen a lot of lawyers who have done a lot of courses on drafting, but they are not good, because ultimately, whosoever is doing drafting, whosoever is doing it, they are not able to relying on this whole principle based approach about having a good connection between the facts, case, question of law, and relief. So, and also, I will also like to reiterate one more last point about this one. If my time, I think time is over. I feel that the drafting process, like let's say, for example, I gave you an example of trademark. When you will be seeing a drafting of writ petition, when you will be seeing a drafting of SLP, and or rather when you will be seeing a drafting of any other legal documentation, every drafting in the first, I told you, every drafting is different, every drafting requires a different frame of mind, every drafting requires a different set of structure, and every drafting requires a different principle. I, being an IP person, might not be a very good and very much expert person in trying to tell you about drafting a bail application. I, being an IP person, might not be able to tell you, okay, fine, what is this RBI guidelines and banking and finance structure? The banking and finance lawyer might not be able to tell me strong arguments about the trademark. So every lawyer and every person is expert in their own panel and is expert in their own domain. So expecting from a person that, okay, fine, this is a lawyer and a legal draft, he might be telling all the legal drafting in one sense, might is foolishly, and I think it is not good. But I feel that eventually when you will learn as to how to draft, you will be having one domain, and you will be having your own domain. Like, you will be going to corporate, you will be going to intellectual property, you will be going to banking, finance, or civil criminal matters, whatever is your interest area relies upon. The drafting process being different, but the main principle is always the same, that what actually you want, what actually you are relying upon, what actually you are what are your arguments, what actually you are the question of law, and actually what is your relief, and according to the facts. So these things are pretty much clear, and I think I should end my small presentation, because legal drafting is such a big subject in itself, that you require a 6 months time, or rather, I told you again, a 20 years experienced lawyer might say that I'm not an expert of legal drafting, leave alone a 2 to 4 year of experienced person. Yes, over to you, sir. If there are any questions, if you feel that I should also repeat whatever I have already been spoken about, I will be very happy to do that. And also, I will request the moderator to also announce this course which you are all going in the last week of February.
Perfectly. Also, there are a lot of questions going on YouTube. I'll just share the YouTube comment section and we can answer those questions.
Yeah, if time permits, sir. One question, I think picture is not clear. You can just zoom it out and I can just read the comments. Or rather, you can just full screen it out. Huh? I can just see that. No, no. See, stop. I don't wanted an answer to this. I am very much happy that you all guys are doing it and you all guys have answered it. But the main purpose of giving you the facts and an example was to make your mind think on that particular aspect, ki bhai, how you will be dealing it when such cases will be there, right? It's a small. Yeah, it is true that negotiation, mediation, compromise after licensing and getting it legal would be, huh? It's very true. Is it on what basis would be liable? Again, not going into the questions and answering. And also, I would like to tell you, if you all are there, I don't know how many people are still there, uh, uh, but Siddharth, I don't know. But this facts of the case was being taken from a very, very, very famous case. I think it is in Ninth Circuit. There was a company of an oil drilling company, and an oil drilling company gave a contract to a person who was actually doing it. That a company, being an oil drilling company, was the only distributor one. They don't used to go and drill the whole land and all the process of oil drilling and all. I don't know about it. So what happened is that this company tried to have a negotiation about with that particular person who was actually doing it. So this was a very famous case, and I will just leave it because you should go and type it on Google, and you should. Very, very interesting case it was. Right? I don't remember the case. I should. I don't. Yeah, I don't remember the citation. Also, I'm so sorry. You can just type it on Google about oil drilling case. It was a very old case. I think of Ninth Circuit or Tenth Circuit. You can just type. Just a small note. My senior is forcing me to initially deny all the points of other party, and then I am forced to type the same again, accepting them, and then I'm forced to. Your senior is forcing you to initially deny all the points of other party, and then I am forced to type the same again, accepting them. See, if you are under, see, as I told you, Siddhartha, uh, I told you thousands of advocates will have thousands of their ways to have a drafting process. If your senior is forcing you, since you are a junior to him, then I think that, being I was also a junior to an advocate, so whatever he used to say, I used to just accept it without even questioning it, right? So on this point, I will just say that if he is saying it for some point, like if he's if he's forcing to initially deny, see, you have to deny the fact. This is something which is also very clear, that you need to have deny the fact. But uh, I don't feel that initially you should deny. It depends on the case to case basis, and if your senior is saying it, I don't find any such reasons not to accept it. But had it been I being there as a part of your panel or as a part of the advocate there, I might not be denying the whole points initially. Rather, that I would have my put my point at the first, and then you will be doing it. Yeah.
We- Also, we have a lot of compliments as well.
Thank you so much.
Yes. So I saw a question right here somewhere.
Yeah, yeah, there was one question I think in the bit.
In the starting of the session, there were a lot of questions. I'll just go there,
Hmm.
let you know. Well, those are more like thank you, sir, and the session was amazing.
Please also do send me the link of this YouTube. I will also read and listen to my whole. I think in the at the starting, please go at the starting. There might
Yes.
be some questions.
So these are all the same questions. I'll just ask all the people if you have any more questions, just drop in.
There is one more question, and how facts should be organized. How to find which fact will help us win, which fact has little importance. Well, very important. I'm glad you asked this question. Very important. In the facts, I feel that, like say for example, since I deal in the intellectual property, out of hundreds of facts, there are only relevant 20%. It is very important in the facts that you need to organize. That is why I told you that you should have facts on your fingers. As per the fact is concerned, the fact should be relying on the question of law. Let's say, for example, all the basic facts which actually relates to your question of law must be analyzed and must be put into the documentation. Not all the facts. See, at one point of time, while drafting it, you will be writing all the facts, right from A to Z. But actually, what is important to your drafting, what is important to your question of law, again reiterating to the four pillars which I told you about the principle based approach, what facts is actually relating to the question of law is what you need to understand and what you need to write it out. So you need to understand. Yes, that's a very good question. That the facts should be organized in such a way, not all, because there are lots of petitions where thousands of frivolous facts are being put forward to just mislead the other party. So you need to understand this. This will be done in your whenever you will be doing such a thing in the future. It will be done, and you need to understand that to organize the fact in such a way that the question of law, the arguments must be in consonance with that. If your facts is such that you are not able to create a good nexus between the arguments and between the question of law, then you will not be able to win the case and you will be having a poor drafting. So please organize the facts. Yeah. Thank you so much. Uh, which practice should we follow? Lohit, I think that this is something which everyone suffers. I think I will use the word suffers in the law college. But since I know that you must be doing some internships, so what I did in my internships previously and how I developed a habit of doing such drafting. I was very much into writings, right? So I used to write articles right now as well. In spite of my busy schedule, I used to take time and I used to write. And at that point of time, since I had some few of my advocates under whom I was interning, I was having some good contacts with them. So pro bono, I used to request them to give me some research work and research drafting issues, right? And this way there were sometimes I also happily got paid by them, but not always. Don't be generous enough. So this is what I did when I used to be an intern. I used to ask my seniors to, okay sir, please give me some drafting work. And they are also busy, so after asking twice or thrice, they will just give you, okay fine Saransh, do research this particular thing and do draft this particular thing. So yeah, this way I think you can create a good habit of drafting even at the initial stage. And also I will request to write articles very much, very prominent, because this will enhance your the research writing skills, right? I'm not saying that research paper is equal to drafting, because if you were there in the starting of my session, I told you that research paper writing and the drafting, legal drafting is totally different. But when you have developed the writing skills, it is very important to have such thing of writing habits. I think this is answered, right? Answered. This what elements are considered to be essential? I told you that you need to have good facts, question of law, and strong basic of things. So I think that is already answered. I just reiterated the same. Also, sir, if in our college, it's also so you should also develop a good rapport with your senior. Ask, request him to send you some work and also write good research articles and get it published. Not everywhere. I will also request to not publish it everywhere, publish it in a very good places. Yeah. Yeah, I answered Lohit's questions about getting into good rapport with seniors and all. Yeah. Hmm. When I was discussing this, I told you that there are issues which is exaggerated. You will find hundreds of case laws. It is totally not recommended because I am telling you with my own experience, the court has bashed and lashed out over advocates who have done just frivolously putting out case laws and frivolously putting out the facts and molding it in such a way that is not even needed. So I have seen that and I don't recommend it, and I myself don't do it because there are a lot of issues where people have exaggerated into such an extent that courts are also being upset by those activities. So please, it's not even recommended. There are no books, brother. I'm so sorry, but to say there are no books. There are thousands of books in Google's, you might say, but I was also very much interested in legal drafting, and I was also very much interested in understanding what the legal drafting is. Believe me, trust me. When I was in my final year, I used to read the books, and I used to read to understand. Okay, fine, how to do the legal drafting. And when I started doing the legal drafting, I found that my drafting is just equals to poor drafting. So there is no book, and okay, you can just get yourself accustomed with the drafting, as I told you about pillars of drafting and all. But there are no books. Instead of books, I always request people to write articles, because when you are writing an article, let's say for example, you are writing an article over the latest mm, give me an example if what latest is going on. Let's say for example, you are writing an article over some issues of voting. Right. So you will develop a good habit of getting into the research question, the hypothesis. So these all small intricacies which you will be finding it out will be very much important and will develop your habit to be a very good drafter. Yeah, but books I don't suggest. Instead, you write in articles and you just do it. There are lots of books here also. I think more or less it is finished, sir.
I think now all the questions are almost the same.
Hmm.
So, advice refers to this formatting plays an important role in drafting.
Definitely. It's very important.
So, how
Nobody can.
long one should take to draft? Asking because I usually take a day or two and it feels a little slow as a learner.
Uh, it also depends on your senior. If you are under an advocate, when I was in under my senior used to tell ki the urgency, it depends on the urgency also. But if you are taking a day or two, it feels like little slow as a learner. I don't feel so. I'm always of the view that if you are having a very good drafting skills, even if you are taking a day or two, not an issue at all. But if it is very urgent, then it might be an issue, because sometimes we have used to draft 20 pages of opposition replies, even 2 to 3 drafts in a day. So it depends on the total urgency, but I don't feel that you should feel a little slow as a learner. It's not an issue. It's good. Where to start writing as a beginner? I think Siddharth ji might be more comfortable person to answer this.
Okay. Also, sir, yes, I think now most of the questions are repeating. So,
Phrasal verb played an important role. Yes, it plays an important role. I have also seen some cases where court have also commented on the grammatical things of the advocate, but but it is not that important. Even if it is expected from an advocate that you are getting into a very good language and grammatical things. It is an expected thing, but eventually if it get mistaken somehow or the other, it might be negotiated as well. So it is not but I've seen some of the courts where the judges have commented on the grammatical things of the lawyer. If the whole paragraph and if the whole grammar is totally bad, definitely the court will be very much cautious upon this, because you are writing not a simple one, but you are writing a strong argument. in the court of law. So it is expected that you are having a very good grammatical command. So yeah, use we a lawyer. There are lots of lawyers who use this software as well. So one can use that as well.
Perfect. So does it mean we should
Eh,
stick to the facts
No,
which
I'm
are
just reading it out. Please, if, does it mean should stick to the facts? When you are trying to argue, right? So when you are trying to draft, it is very important that you are sticking to the facts, which is related to the law only, and which is important to the case. But I will recommend that when you are appearing before the court, your whole sole concentration should be on the facts from which you are trying to retaliate on what you want and what question of law you are addressing it out. Because believe me, trust me, I have not find any such lawyers to whom judges are giving ample of time. There are might be some of the very, very, very important and landmark cases where the senior advocates might argue for long, but in a general practice, you might not be getting much time. So if you are writing lots and lots of facts which is totally unrelated to law, which is you are actually addressing, you might end up not even coming to the point. Right. So it's just like let's say for example, if you are giving a UPSC paper, in this paper you have seen that a question they says write it only in 150 words, 15 marks, and you start writing from the history, then you have not even come to the point, and your 150 words they will be over. So it is important to have stick to the facts, and actually important when you are presenting it to the court. And because courts are also very much good in addressing this particular facts only, they will directly come to the point. There, the facts and the law are substantiated in a very good manner. Yeah, please next. Siddharth sir, please tell us, sir. Please tell us.
I'll
Shall I do the
definitely drop in the mails of all the sites that I
yeah.
find out.
Yeah, yeah. So I do the same drafting applies. Income tax. Sorry, brother. I told you there might be different of IPC. There, I'm not an income tax drafting. I'm not drafted an income tax, so I don't know about it, brother. I'm so sorry. Does easement that come under the landmark cases? It might be coming if it is addressing a huge and good one, but I have not find any such law. Might be my study might be very much weak about that act, but I might have not find such landmark cases. But yeah, if it is addressing a major question of law, why not? It should come under landmark cases. Sir, give me my answer. Rashmit Kaur, what is your question?
Okay, let's we can have a quick feedback round.
Yeah, and also you can just tell that you will be having this program. So all those questions like income tax drafting is also in the module. So we will be deliberately dealing in all those sort of things.
Right.
So
So we
you
are
can just
having our session on civil legal drafting, and all of you can enroll for it. We will be answering all these questions. We'll be going in depth with all those things, and I'll share the link on the group as well as on your mail, and you can register for it from there.
all experts from all the domain will be there. And like you are asking Namanji that income tax drafting, like so there will be an important lawyer of that particular area. So you will be getting a more good exposure. Can a case be dismissed due to poor drafting? In Delhi High Court, I think Justice Pratibha ji was there, and I was also in that. I was looking onto that, not directly, but indirectly. And Pratibha ji complained about the poor drafting, but she did not dismiss it. It is. I am telling you my the real fact which happened. So the judge might comment, that is totally definitely it, sure, but that particular example I don't find that the judge dismissed the whole case only due to poor. They mentioned it that the poor drafting is there, and the petitioner should take another advocate or should take another advocate like this. So they have commented there. It was a real insult to the petitioner as well. Yeah. Okay, class, I must leave now. Acha, please for it. Thank you, sir, for available. Thank you, sir. Thank you. Receive from legal notice feedback form, please. You can just provide the feedback form, sir.
Surely.
What are the necessary conditions of legal notice, sir? The necessary conditions, that is the why the notice is there. The facts and the things must be very very clear. And also, again reiterating, there is no universal rule of the conditions of legal notice. The legal notice is having different procedures, different processes, and you might have different thousands of legal notice, might have thousands of the process. So facts and what you actually want to say. Also, I will, since you have spoken about legal notice, I will also say that the legal notice, despite being, uh, see, lots and lots of cases arises due to legal notice. And I find that legal notices are, especially in trademark copyright, where you find these all picture movies getting into an agreement or something like that sort of. So in that case, they are sending some legal notice, they are sending some rejoinders. So they are poorly drafted, right? So again, reiterating the same, facts are something else. What you are trying to address is something else. So no such strong condition of legal notice, but yeah, the pillars of drafting which I was trying to tell you all was, might be the same in the legal notice as well. But it's it's but it totally depends on the facts and all the things, right? So yeah,
Right.
can you just do ऊपर थोड़ा सा, नीचे, अच्छा, I thought a question was there. Yeah, sure. Please choose. There are also BBA LLB going on. Lots of people used to do, and BBA LLB is a good one. You are also know the business aspect as well. No, there are suggested. If you will go to the Supreme Court website, there are all drafting formats being available in the Supreme Court website, SCI online wala. So you can just find it out, and you can just do it, right?
Perfect.
Valentine week is near, and I'm still single. I'm so sorry about that. I cannot help this.
Okay, so I think it's been a great session,
Thank you
and
so much. Yeah.
with this, I'd like to conclude this session. All of you who are live on YouTube and are watching it, if you like the
Can we
session,
just remove the chat?
please drop a like, and we'll know that you like the session. So there's a delay of 10 seconds. So we'll
Mhm.
just wait and see for the feedback. Very nice, informative session, a great day. Thank you. Yes, great session, very insightful. Thank you, sir, for the amazing session. There are two more questions. How much detail I should go in about drafting as a first year student? And so whether
I
maybe,
think you should first of all have a good command over law. Matlab, I have seen first year students doing all sort of drafting. It's good, its habit is good, but I feel that at least first or second year you should go totally onto the basic concept and basic ideas of law, and then you should come to drafting. Because the it is it is like saying that you are trying to make a food, but you have forgot what the ingredients are.
thank you, sir. Thank you. Great session. And what about Blake's dictionary, sir?
I don't have any. I have never used this, to be very frank, and might not be able to answer about this particular big dictionary.
Perfect. So with this, I will conclude this session and I'll stop sharing the screen. Thank you so much, Saransu, for your valuable time. It has been a great session and a insightful session. All of the students might have learned a lot from this session, and I'm hoping they will learn more in the upcoming
Thank you
classes.
so much.
Do let us know how you like this session and what all things are you looking forward to.
Thank you so much, and also thank you so much for the opportunity. Thank you so much. I will definitely be happy to be again on your forum.
Surely, surely. We'll also love to call you back and have another session with us soon.
Definitely.
And with this, I'll conclude this session. Do join us in our next live classes that are going to be conducted. All the details will be floated on your email IDs. With this, I conclude this session. Have a nice day. Be safe. And thank you, Saran sir,
Thank
again
you.
for this
Thank you
valuable
so much.
time.
Thank you so much. Thank you so much.